Good morning. It is 9:30 a.m. on the Wednesday, the 17th of February 2021. My name is Arran Hunt. I'm a partner here at Stace Hammond, and I head up the Migration Partners team. Now, those of you who have been watching these videos for a while will recognize my apartment. Auckland is back into lockdown as of a couple of days ago. We're waiting to find out whether that is going to be lifted at midnight tonight, or whether it'll be extended further. Our assumption is extended further for a couple more days. I think most of New Zealand, or at least most of Auckland, has that feeling that 2 more days in lockdown or 4 more days in lockdown, take us through the rest of the week, is probably better as a safe sort of environment for Auckland. But we will find out this afternoon what this video is about. I wasn't planning a video today, but we finally received an email yesterday from Immigration New Zealand, which we were waiting for some time. Now, you might remember that I think it was on January 17th, we did a video looking at the 1,000 students which Immigration New Zealand had announced that they were going to let back into the country. Now, this was announced as being students who had already been in New Zealand doing a qualification. That study had been interrupted by the border being closed, and they had been caught offshore. Now that was going to be for qualifications that were level 7 and higher. I believe it was bachelor degrees, level 7 and higher, where the person had definitely been in the country doing that qualification in the past, sort of 2 years. Now we have, that was what, January 17th, we announced that. I think we got the email from immigration on that day. We did a video pretty quickly. Last night we finally received the rules. That is a month later. It just shows you that at times immigration may sort of get the information out, waste the announcement out faster than the actual the information that comes through afterwards. Of course, we have questioned to some degree how that was going to take place due to the MIQ being fully booked till the end of May. And immigration was talking about people arriving over a several month period, sort of spreading them out. Now, we're going to go through what they have provided. We will see that they're looking at this starting in the 1st of April, but applications can be made now. So we're going to go through the changes to the operational manual, how they're going to work in practice. It doesn't answer all of our questions. There is no as to what happens if there's more than 1,000 applications. The original announcement a month ago talked about how the Ministry of Education would choose who got the visas, who to bring back in, and it was mainly focused around those who were at the closer to the end of their applications. Now, if you're those who apply now, is it they're going to be? You think there'd be some sort of cut-off date that they'll cut off the applications and pick the best 1,000, or is it going to be first in, first served? That doesn't seem to match the original idea that it would be those who were at the tail end of their application, sorry, at the end of their qualification. So it's not quite clear as to how they're going to allocate these 1,000 places to students. We do know as the applications that opened a few days ago, they made us aware yesterday that the applications were open and that these new rules were actually now in place as of the 11th, I think it was, of February. We will check the dates as we go through them. I'm just going from what I read through just last night. And hopefully there's some good information there for you. Of course, this will not apply to those of you who have been allowed to come to or have been offered a place in New Zealand but have not yet been studying in that qualification. This does not apply to you, just those who have already been in New Zealand studying. It allows them to return to New Zealand. There's also a small tweak to the 250 PhD students who were allowed previously or have been allowed to come in. There was a small tweak to the operational manual for a clarification there, which we're going to see as well as we go through this. I'm going to change to a view of the amendment circular. Now, the amendment circular is something that gets sent out to lawyers like myself, to immigration advisors. Whenever there is a change to the operational manual, the amendment circular is what explains what has been changed. You'll see it's the highlighted yellow. That is where there has been a change in the operational manual. These the amendment circulars are available online, but typically they are not available until perhaps a week or two after they actually come out and get released. They don't go on to the immigration system until afterwards, but they are available online if you want to look at what was happening. But by the time they do appear online, they should also appear within the actual operational manual online as well. And of course, for those of you who don't know, the operational manual is the rules that Immigration New Zealand apply to an application. It is better to look at the operational manual than to just go to the immigration website and look at what their general information is. The ops manual, as we call it, or they call it the instructions, often when they write to you, is what Immigration New Zealand are actually applying when they do these applications. Process the applications. Now, okay, we're going to change view to a view of the changes they have shown. We are going to go through them not in so much the order from top to bottom. We are going to jump around a little bit. This makes it a bit more common sense to jump around to. Then you can see that the process from what they've put in there. On doing the edit for this video, I realized we had not done our disclaimer. As always, this video is not legal advice. It is merely our commentary on what is happening with immigration here in New Zealand. And in this video, we're looking, of course, at the changes to the operational manual and just going through what the changes are. If you're looking for legal advice fit for your situation, please get in contact with us via our email of visa@shlaw.co.nz, or come to our website. This is our new website here. Click on contact us and fill out the form down here below, and one of our staff at our offices will get in contact with you. Okay, first we're going to have a look at H525. Now, those of you who have watched these videos before will know that this is where most of the critical purpose visitor visa allowances are in. Most of those border exceptions all fall under this category, with the exception of those coming from Australia who are hidden away in A15 for some reason. Now, we'll look down here. Now, the changes that have been made or announced yesterday have actually now appeared in the operational manual, so you can find these within the manual yourself online, but we are going to look through the document they released. It makes it a bit easier because everything's highlighted in yellow. Now, the important thing here, of course, is the H52515, which many of you will have heard me speaking about a lot, because we talk a lot about Section F, which is the parent and guardian, the travel with New Zealand citizen resident class holder section. Now, under here though, we have C, which allows for a class of individuals that meets the requirements set out in H5/3021, which is an exception agreed to by Cabinet, being of course the government. Now, H5/3021 is where we're going to find these exceptions when we look through the actual amendment circular. Now, this is the amendment circular. These are available online typically a week or so after we get them through from Immigration New Zealand. We usually get these before the changes will appear in the operational manual. For some reason, Immigration sent it to us yesterday, but these changes actually came into effect last week, so we were sort of told after they'd come into effect. So yeah, effective from 11th of February, and then yeah, so now scrolling down, we're going to start near the end first. I will show you why. So to page 22. This is U640. Now, U6 is a section that relates to student visas. Now, this here allows, of course, this is the H52515C reference. It allows for students invited to apply based on having a critical purpose for travelling to New Zealand under that section we just looked at, because they belong to a class of individuals that meets the requirements under H5/3021C3. Now, this allows for travel no earlier than the 1st of April 2021. So that is going to be the first stage that a visa is eligible for. You can apply for this visa now, and that visa can be granted, but the entry date should be from that date forward. We're going to go back up here and look at H5/3021, which is here. So H5/3021, this is the approved classes of individuals that the Cabinet has said they will allow. Now, I mentioned there was
alteration as to PhD and postgrad students. That's the 250 that came in previously. It's just been a clarification that that does not include partners or dependent children who are eligible to come into the country if they were included in the application. Now, this is the new section here. Again, this is visible on the Ops manual now online, but it's in relation to priority returning international students of studying for a degree or postgraduate qualification. Now, degree means level 7 bachelor or higher than that. So if you're doing level 7 but not a bachelor's degree, you're doing a diploma, that's not going to fall under this allowance. You have to be level 8 or above, or level 7 doing a bachelor's degree. And it's for returning students, so those who have already been studying the qualification, so they had commenced studying for a degree or postgraduate qualification in New Zealand, hold or held a visa to study in 2020 but unable to enter New Zealand to complete their qualification. So they could have been in New Zealand in 2019, they could have been in New Zealand for part of 2020, but for whatever reason they left. They are nominated by the education provider. Now, we're not quite sure what this actually means, this nominated by the education provider. That nomination could be simply that they have been given admittance, or as a letter from the education provider to say, yes, we want them to be here. That's one part that they're not that clear as to what that means. We did mention previously that there was this increase to $20,000 per year of living expenses. Now that has been $15,000 per year for a number of years, and we've been waiting for Immigration New Zealand to increase that amount. It's now $20,000 per year, or $16.67 per month if you are going to be in New Zealand for fewer than 36 weeks. They'll work it out on a per month basis. More than 36 weeks or 36 weeks, then $20,000 per year. Less prepaid living expenses. So if you had prepaid living expenses, it would be $20,000 less that amount. And have sufficient funds to cover the cost of managed isolation and quarantine. Now, this is actually mentioned a number of times throughout the changes. They sort of really do cover themselves that the $20,000 does not include the MIQ costs, and we'll see that as we go through them. Worth mentioning that partners and children can be included if they are allowed to be under current instructions. It's up to 4 years is the permissible visa length. Ministry of Education are the ones that requested this, up to 1,000, not including partners and dependent children, so of course it could be more than 1,000 people coming in, and the other parties involved are education providers and tertiary education sector groups. Now again, it mentions here that the payment of MIQ is in addition as a requirement under the law, as is payment of any as is inclusion. They have to also include the partner in the application. Now we saw that in the those who came in as critical health workers. If the partner wasn't included in the application, they could not come in at a later date. They could come in if at a later date if they had been included in the application and had a visa granted. They weren't required to travel with the person, but they could arrive later. But if they weren't included in the application itself for a border exception, they couldn't then apply for a border exception themselves later on, leading to this horrible fetch situation we are seeing for so many critical health workers. So again, we saw that one previously. Now scrolling further down, here we go. Now what was interesting is that when they announced the $20,000 requirement, the expectation was that was going to be the norm going forward. They haven't at least drafted it that way yet. What you'll see here is that it's still $12.50 a month for students unless they're coming in on this exception, at which point it's $16.67. Now we expect that when the border does open, they will update this again so that that will be $16.67 for all students. We can't see why they would charge more for those coming into on the exception and then less for everybody else. This will be the norm. Sorry, the $16.67 will be the norm, we believe, going forward once the border has opened. And the same again here. It says 15,000 still unless you are doing the border exception. We believe that 20,000 will be the default once the border is open. This will be updated to just make it the 20,000, unless of course you come from Samoa or Tonga with a written guarantee of maintenance from a relative. And of course mentioned in regards to the fact that the 20,000 does not include managed isolation and quarantine. Now there is one more important thing in here, which is an interesting little thing they've drafted in here. Now, applicants who apply have to show they have sufficient funds to pay for the cost of their stay, so that the 20,000 or the 1667 per month, and for managed isolation and quarantine, or written confirmation from the education provider that the cost for the applicant's stay in MIQ, if any, will be paid in full or part by the education provider. And then here, if it is in part, then the applicant must pay the remainder. Now, this little bit about the the education provider covering part of the managed isolation costs is an interesting one, and I've been thinking about why this has been included. Now, typically we would expect that cost to be paid by the applicant, and it doesn't make sense for the education provider to spend more time on handling those costs, so they accept the managed isolation costs from the applicant, and then they pass it on to the border control or to the government, especially when they sort of put that liability on themselves, because once there's written confirmation from the education provider, the cost of paying for MIQ falls onto them, which just doesn't make sense. Now, the only scenario we can see that making sense, and this is us just looking at how they've written things and looking at why it may be done that way, is if this has been included for an allowance for education providers in the future to provide managed isolation. They've been looking at doing that for a while. They've been asking to do that for more than a year, and the government has been saying no for quite some time, but there was some discussions recently that that the government was now taking it in more consideration to it as being a possibility. So this has been drafted with that in mind, which would mean that those discussions could be further along than we had thought. If that is the case, then we could be seeing education providers providing MIQ to students coming in. That would take pressure off the border. It would then also possibly allow more students. And it means that the cost of the MIQ would be paid by the student, or at least partially paid by the student, to the education provider, and then part of it would still probably go to the government for doing the overall review, and that is why there is this allowance here for partial payment to the government from the applicant, with the rest being paid directly to the education provider, who are the ones who will be providing MIQ. So that is just us looking at the way it's drafted and looking at why perhaps it's drafted that way. At the moment, there's been nothing official as to education providers providing MIQ, but the way this has been done, it strongly suggests that that is going to be something coming forward, which is fantastic news, we think, for all the students wanting to enter the country, because it will mean many more students being able to come back in. Now, as to the cost, of course, it can be done by funds, sponsorship, undertaken by a third party, and of course you can also get a full scholarship, which could include the cost of managed isolation. And that is about all the changes that have taken place. Of course, here, this is the suspension that's currently in place, has been extended until the 7th of May for other applications. The suspension, of course, can be pushed back further if the government sees a need to, but at the moment, that is about it. And that's all we have for you today. There has been no other information on any other visa types, nothing to do with partnership visas, or any other allowances. We are still waiting to hear from immigration as regards to whether they're going to push back the cap dates to past 31st of March. We have had a few of you write to us regarding declined cap applications, which have come through declined the last few weeks. Now, one thing to note on that quickly is that people who assist you with applications, they must be either a licensed immigration advisor, or they have to be a lawyer like myself who's exempt from licensing, or a Minister of Parliament in New Zealand, or several people like that. if you do have somebody, especially those who are offshore, who is assisting you, they are actually breaching the rules. So if you did have someone who wanted to assist you, but then they didn't want to put their name onto the application as an advisor, then we would strongly suggest you look at talking to somebody else to submit the application or submit it to yourself. The issues we're seeing is that people have used agents to make applications. Those agents are not licensed immigration advisors. They are this they're filling out the form for you and charging you for the service. Immigration New Zealand will then often see the same name appearing, perhaps using the same credit card on a number of different applications, and that raises a little red flag in their systems that this person is likely acting as an agent. Now, if Immigration New Zealand say to you, did you use an agent? Our advice to our clients, at least, is to be honest with immigration. Because if they ask you a question like that, most likely they strongly believe you did. And if you can't prove otherwise, then you are likely going to have a character issue, which could lead to not being able to come to New Zealand. So, yeah, rule number one is do not use unlicensed agents. If you're going to use someone to assist you, talk to a lawyer in New Zealand who's exempt from licensing, or talk to a licensed immigration advisor. You can go to the LIAA website and search for advisors, or go to the New Zealand Law Society and search for lawyers, or come and see us. We can assist you. That is all we have for you today. If you like this video, please click on that like button. It really does help us get the word out to everybody else. And if you want to hear about future videos, please click on subscribe. And we'll be back to you when we have more news from what's going on here in Immigration New Zealand. Hopefully we'll be out of lockdown shortly and back into the office. As always, kia kaha and stay safe.